Go.
Good afternoon, my name is Claudia Cardosa and I will be presenting the Title IX of Educational Amendments of 1972. So first, a little background of the law. The Title IX of Educational Amendments of 1972 is a primary law governing sex discrimination and admission policies. Title IX states that implementing regulations, no individual may be discriminated against on the basis of sex in any educational program or activity that is receiving federal financial assistance. So these are the types of harassment that are prohibited by the law. The first one is a quid pro quo harassment. This means that a school employee or staff may not explicitly or implicitly condition a student participation in a school activity or program, including extracurricular activity or athletic activity. The other type of harassment is a hostile environment sexual harassment. This type of harassment just pretty much states that there can be no type of hostile environment in a school. This can be an elementary school, secondary school, institution of higher education, university, or even vocational schools. So who does this law apply to? The Title IX law applies to all public and private educational institutions that receive federal funds, including elementary, secondary schools, school districts, school properties, colleges, and universities. Who does the law protect? The law protects students in connection with all academic, educational, extracurricular, athletic, and any other type of program, whether the programs are at school premises or outside the school. Provision of the law. Institutions subject to Title IX admission requirements are prohibited from treating individuals differently on the basis of sex in any phase of admissions or recruitment. The first point states that giving preference to one person over another on the basis of sex by ranking applicants separately on such basis or otherwise. The second point states apply numerical limitations upon the number on proportion of persons of either sex who may be admitted. And the last one states otherwise treat one individual differently from another on the basis of sex. And all this can be found in the Code of Federal Regulations number 34, section 106.21 under the Title IX. So some exceptions to the law. According to Kaplan and Lee, institutions that are exempt from the Title IX admissions requirements are not necessarily free to discriminate at will on the basis of sex. Some of these institutions will be caught under the 14th Amendment clause, which states that, which is a protection clause that states restriction on public undergraduate schools, even if they are single-sex schools exempt from Title IX. Provisions of the law. So some private undergraduate institutions are not prohibited from discriminating admissions on the basis of sex, nor are public undergraduate institutions that have always been single-sex institutions. Also, institutions that are prohibited from discriminating in admissions are graduate school, professional schools, and vocational schools. These two court cases are very important to the law. The first one, the Supreme Court case Franklin versus Gwinnett County Public Schools, was the first ever Supreme Court case that dealt with sexual harassment claims under Title IX. And the second one, the Mississippi University for Women versus Hogan. In this one, the plaintiff challenged an admissions policy that excluded all males from a professional nursing school, which was Mississippi University. So the plaintiff was a male who wanted to be admitted into the university, but the university had always been serving women. So in this case, he ultimately won, and then that is how this court case is very important to the law. So how can these claims be prevented in an institution? A way to prevent this is by creating a policy, and that this policy specifically prohibits sexual harassment, and having a separate grievance procedure for violations of this policy is very important. Another way to prevent this is to further training administrators, teachers, staff, and any staff in the school, just pretty much modeling appropriate student conduct and types of conduct that can be implemented in the classrooms and in the school. And like I mentioned before, this law not only applies to activities that are in the school, but they also apply to activities that are outside of school. Thank you.